our second speaker in this panel, Professor Regula Ludi, here she is, who is a professor of modern history at the University of Zurich, the Interdisciplinary Institute of Ethics and Human Rights, and the University of Freiburg. Professor Ludi has published widely on reparations and restitutions, including the monograph Reparations for Nazi Victims in Post-War Europe, year 2012, and Second Wave Holocaust Restitution, Post-Communist Privatization, and the Global Triumph of Neoliberalism in the 1990s. This was published in 2018. Other research areas include the history of refugees and asylum in the Nazi era, human rights history, and the history of crime and criminology in the 19th century. Her most recent project deals with volunteering and volunteer work since the 1970s. Professor Ludi will talk with us about what do reparations do to claimants, looking at reparations from a praxeological viewpoint. Please.
So I was told it was really hot up here. I'm going to get some water first before I start my paper. Okay, first of all, I would like to thank a lot for the invitation to that conference and, of course, the organizer for bringing together so much people working in the field of reparations and to give us the opportunity to get acquainted with so much new research with so many fresh findings. What I will talk about today is not based on my new archival research, because I haven't done archival research on reparations for a while, but I have a pretty big collection of excerpts and photocopies and notes I took in the archives, and I reread those files. And as historians know, rereading documents always bring you new insights, and you discover new things. So just to say a few words about the methodology of what I will do here. And also, that's a second remark I have to make. I'm gonna talk more about methodological reflections rather than findings, and about theoretical approaches one can take to the practice of reparations. So I guess I'm the first one who is not specifically dealing with the Luxembourg Agreement at this conference. The historiography of Holocaust reparations is on the upswing, as we could learn so far at this conference. Fresh findings have deepened our knowledge and added much nuance to this history. We are well informed today about the legal, diplomatic, and political history of reparations. Recent studies have also broached the interconnections between restitution and memory constructions. The restitution campaigns of the 1990s have drawn attention to the global dimensions of the Nazi-era legacies and stimulated the examination of transnational implications of reparations politics. The practice of reparations, however, and the way reparations have shaped survivors and their identities still is an underexplored subject. This gap is partly due to the lack of source materials. Survivors rarely touch reparations in their memoirs. As one author put it, narratives about financial compensation remain private and inaccessible. Just a handful of studies have used oral history interviews to explore claimants' experiences. One of these rare exceptions is the book by Susan Slajamowicz entitled How to Accept German Reparations. An anthropologist by training, Slajamowicz reconstructs the reparations history of her Holocaust survivor family. She uses reparations as a lens to focus on the grappling of her mother, father, and grandmother with their history and identity as survivors. By asking the question, why do people pursue reparations? She places the main emphasis of her studies on the conflicting personal motives to claim monetary payments by applying the method of, as she calls it, intimate ethnography. Her account, pointing to the moral and psychological dimensions of reparations from the claimant's perspective, can stimulate historical research. However, our source material rarely allows for an insight into the reasons driving survivors' decision to claim or not to claim monetary payments. Thus, I would like to rephrase her opening question by asking what happens to people if they do pursue reparations. Just to prevent some misunderstandings here, this will not be about money or blood money, and it will also not be about red tape. It will be about sort of the ordinary bureaucratic procedure, of the ordinary practices of handling reparations claims. So to answer my question, what happens to people if they do pursue reparations, I rely on individual compensation files. And for this paper, mostly on West German records. At first glance, these records appear not very yielding for such an enterprise. They are rather monotonous and organized in a way typically reflecting legal damage categories. So we have the performance of the law, as Leora just mentioned. Thus, these files mostly include records that document damage accounts, such as inventory lists, tax records, calculations of lost income, medical reports, and other expert opinions. The personality of the survivors and the uniqueness of their experience disappear behind a wall of bureaucratic formalities and are fractured through the prism of highly standardized forms and technical matters. Obviously, claimants also prefer to avoid direct contact with compensation agencies and entrusted legal representatives with the management of their claims, so they are largely absent. But there are exceptions. Cases of claimants who were heavily engaged in the procedures, who challenged the authority of compensation agencies and thereby often revealed hidden premises, unspoken norms, and guiding principles of compensation practices. So let me start the following reflections with a quote by a German Holocaust survivor from Munich. I will call him Max B. In this paper. In 1956, in a letter to the compensation agency, he declared, I quote, "Let me emphasize and make clear that I am entitled to payments and that I am not a supplicant." End of quote. In the German original, it says, "Kein Bittsteller." A matter of course, we would assume. Yet this was obviously not the case. Not only did the claimant feel compelled to state the fact of him not being a supplicant, that is, someone asking submissively for a favor, but he also emphasized the impertinence of being addressed as such by positioning himself as someone who is entitled to benefits. This episode is telling. With his insistence, Max B. exposed the interaction between him as a claimant and the reparations agency as a relation that can be characterized as an interpellation. and interpreted within the framework of theorizing on subject formation as subjugation. Originally introduced by the Marxist philosopher Louis Althusser, interpellation describes the performative constitution of subjects in social interactions. According to Althusser, ideology is embodied in the rituals of social and political institutions, or in our specific case, in the operations of the compensation agency and its interaction with claimants. By addressing individuals, the institution and their agents respectively invoke ideas about subjects' identities. Thus, the subject is not pre-existing, but emerges in the act of the interpellation when the individual responds to being called upon. With its response, the individual recognizes and internalizes the ideas and values of the institution. It recognizes the institution's symbolic power to name and to summon. As Judith Butler, as most of you probably know her as the gender theorist, but she has written much more on, among others, sort of the performative construction of subjects. As Judith Butler puts it, I quote, the act of recognition becomes the act of constitution. The address animates the subject into existence, end of quote. The individual is put in place, given a place by the very act of being addressed. In other words, the individual becomes a subject via subjectification, that is, a responsible and rationally behaving person vis-a-vis the institution. A subject in its dual meaning as someone who is an agent and owes their existence to subjugation. Again, Judith Butler, I quote, interpellation requires the recognition of an authority at the same time that it confers identity through successfully compelling that recognition. Identity is a function of that circuit, but it does not pre-exist it, end of quote. And one could also add, it is also a result of that circuit. As Butler points out, however, the workings of interpellation are neither mechanical nor fully predictable. Interpellation is not a hermetic concept and does not suggest predetermined outcomes. This is exactly what happened in the case of Max B. With his objection, Max B obstructed the interpellation by exposing its operation and the ideas embodied by the practice. He rejected the authority, the symbolic power to name and to classify. In so doing, he revealed truths about reparations as he laid bare the hidden ideas and values embedded in its practice. So what made Max B think he was addressed as a bittsteller, a supplicant? What does his intervention reveal about the working of reparations? Before exploring these questions, let me briefly add some remarks about the semantics of the complaint itself, of being treated as a bittsteller, and the kind of relationship this term implies. A bittsteller is someone asking for help by invoking compassion, a moral sentiment on the part of the vis-a-vis. In his analysis of humanitarian government, the anthropologist Didier Fassin contrasts the appeal to compassion and the social relation it evokes with the appeal to solidarity or an obligation. Unlike the latter, compassion, I quote Fassin, is a politics of inequality, end of quote, and is premised on an asymmetrical hierarchical relationship between the benefactor and the recipient, or in our case, the supplicant. With the appeal to compassion, a supplicant is asking for a favor, not for something that is owed to them. But who exactly was Max B, and what do his specific complaints tell us about the way compensation practice formed subjects and identities? Born in the early 1980s, Max B was a Jewish businessman and landlord from a middle-class background who was married to a non-Jewish woman. Until the early 1930s, he ran a fashion store in Munich. While he organized the escape of his mother and sister to the United Kingdom, and even after the Nazis' rise to power funneled some of his assets abroad, he missed the moment to leave Germany in time. He survived the Holocaust in Munich, spending the last 2 years of the war in hiding. His compensation and restitution claims included the alienation of his property and business, the looting of his assets and loss of income, the destruction of his home interior during the November pogrom, a 3-month captivity he spent as a prisoner of the Dachau concentration camp after the November pogrom, forced labor at the Milbertshofen camp in the 1940s. Milbertshofen camp in Munich was the main collection point for the deportation of Munich's Jewish population, and finally the 2 years he survived in hiding. Max B presented these facts in a matter-of-fact manner. The tone of his account only turned more emotional when he got the impression that the agency questioned his statement, which repeatedly happened. To Max B, this constant questioning was one indication of him being treated as a Bittsteller. Such scrutiny put him in a situation where he constantly had to remind the compensation office of its outstanding debt. And he compared his situation to that of many former Nazis, as he critically observed in the mid-1950s, who had a long time ago received generous pension payments and compensation for the losses they suffered due to the denazification and the expulsion of Germans from Eastern Europe, what we just heard from Iris about. Official distrustfulness also resulted in decisions that, in his view, distorted facts, banalized the brutality of Nazi measures and the lethal menace he was exposed to as a Jew, or even worse, mocked the distress he suffered. He responded perplexed when asked to provide additional evidence to prove the inhumane conditions under which he lived during his time in hiding and as a forced laborer at the Milbertshofen camp. And he returned the question by asking of what exactly inhumane conditions would mean if hiding in an unheated attic without access to running water, with no ration cards for food, and with no access to shelter during Allied air raids, and the constant fear of being caught did not qualify as such. This was just one example of the distortions he saw at work in the agency's judgments that questioned the truthfulness of his own accounts, which he understood as the refusal to recognize him as a candid, reliable, and worthy citizen. His responses indicate how interpellation worked. By disputing such decisions, Max B exposed the agency's mistrust of claimants' testimony. As a general operation, such mistrust materialized in diligent examination and scrutiny of all statements coming from survivors. Although false statements were subject to criminal liability according to most legislation, claimants still had to prove their declarations with written evidence. If they failed to do so, since records were no longer available, compensation agencies required expert opinions and witness testimony instead to confirm even the most obvious facts. If coming from survivors, such testimony was again subject to scrutiny. Systematic distrust thus addressed claimants as principally unreliable individuals. Their trustworthiness being doubtful, they had to establish their credibility and carefully avoid contradictory accounts over an extended period of time until the agency took a decision. Scrutiny of their claims assimilated their identity to that of a suspect in a criminal investigation, though with reversed signs. Survivors appeared guilty until proven innocent in the final act of being recognized as deserving victims. And even then, a cloud of suspicion continued to hover over them, such as the suspicion that they could supply false declarations, that relatives would cash pensions after the death of the beneficiary, etc. In brief, innocence was not an attribute of victimhood, but instead a precondition of the recognition as a deserving victim. Just the truly innocent individual thus constituted a worthy and reliable subject, but only under the condition that they could establish their blamelessness. Beyond agonizing examination of their statements, the establishment of claimants' innocence also depended on whether their lives before and after persecution corroborated their irreproachable behavior and character. The touchstone of their innocence was their biography as reflected by official documents. By rejecting the identity of a bittsteller, Max B. thus refused the kind of subjugation required for recognition as a worthy victim. By taking the position of someone who is entitled, he rejected the identity of an examined subject, of someone who had to prove his innocence. He expressed his sense of entitlement, for instance, by juxtaposing the delay of payments he was owed with a smooth and generous compensation of former Nazis or Germans from the East. To Max B., their privileged position represented a violation of his rights and entitlements, and by adding insult upon injury pushed him into a subordinate position. He offered to offset the taxes he owed the state with the compensation that he was due. In many cases, recognition as a worthy and reliable claimant also required recognition of a non-familiar, narrow, and undesirable identity. Even the identity of the victims was not particularly attractive to many survivors, carrying ambiguous connotation, especially in the early period, post-war period, and was one of the identities many survivors tried to avoid. Recognition as a victim of racial persecution, contingent but essential in the case of Sinti and Roma, risk exposing claimants to continuous discrimination in post-war Germany. For well-integrated citizens, claiming reparations implied coming out as gypsies and being associated with all the negative prejudice against this group. In compensation practice, the state's symbolic power to name and classify thus produced and reproduced taxonomies and hierarchies that reiterated claimants' powerlessness. As a second point, Max B.'s rejection of being a supplicant implies that he did not want to be seen as a welfare recipient, an applicant for relief, and that he was not asking for compassion. He thus insisted on a clear distinction between what he deserved because he was entitled to it and what would be given to him in an act of benevolence. In so doing, he revealed that reparations practice addressed claimants as if they were asking for relief. Addressing claimants as if they were asking for favors obviously was routine, and the impression the compensation office left with all those who presented themselves as needy individuals in their letters to the agency. Most of these letters were pleas for a more expedient handling of claims, with the authors portraying themselves as incapacitated and unable to find work, or they referred to their mental and physical suffering and appealed to compassion with their frequent reference to their dire economic situation, their deprivation, and their urgent need of benefits. Claimants adopted the identity of a supplicant beforehand, and in literally calling their claims a request for assistance, divined that their interaction with a compensation agency would entail a relation of compassion. They were not wrong about that. However, the moral sentiment of compassion carries no obligation to deliver on the part of the benefactor. Compensation agencies replicated that pattern by refusing to allocate benefits for many obscure reasons, or almost indefinitely delaying decisions. As a social relation, compassion is a gift relationship, but one with no possible reciprocity. The receiver is in no position to return the gift at an equal level. For claimants, this created an awkward situation. If addressed as beneficiaries of acts of compassion, they remain in a situation where they are expected a gift in return. They seem to have an obligation. But what could that possibly be? Gratitude for being recognized as a Nazi victim, as a reliable person and deserving victim, forgiveness of the abuse, recognition of the symbolic state power to classify, categorize, and define their identity, to give them their place. There is no answer to this conundrum, just conjectures. And thus, this in turn may be another reason for Max B's vehement rejection of the supplicant identity. To sum up and come to a conclusion, Max B's complaint implies three conclusions. First, it conveys that in compensation practice, the interpellation constitutes claimants as subjects with a subordinate identity. That is, their recognition as deserving victims is premised on their subjugation. As we have seen, subjugation starts with them being examined. An examined subject, a subject of examination with objectifying impact, and a principally unreliable and untrustworthy person in a limbo and suspicious. Second, this complaint implies that claims are being transformed into an appeal to compassion, a supplication, and in doing so turns claimants into supplicants. And as a three-point compensation practice thus blurs the line between injustice and misfortune, which, as I have argued earlier, helps distinguish post-war reparations from relief programs. Reparations, according to my previous definition, thus would conceive damage as the result of wrongdoing and thereby also raise the question of responsibility. Yet this operation obviously fails if the claimant is put in the awkward position in which they have to ask those who act in lieu of the perpetrators for a favor and appeal to their compassion. And in the end, when judged by practices, this again raises the question, what are reparations all about? I thank you for your attention.
Thank you. I see a lot of connections between the two talks. I already wrote questions about it, but it seems to me that if we have to choose between compassion, what you were saying, and need, and a right that compels us to identify as Germans, I don't know what is the worst scenario, but both ways have their cost, right?